Thank you, Judge Yates, for your introduction and your very kind words. And to our brother Kev Carmody, who continues to be an inspiration to all of us. Vice President of the Law Society of Western Australia. Distinguished guests, ladies and gentlemen, I too would like to acknowledge the Whadjuk people, the traditional owners whose on country we meet today. In doing so, I'd like to pay my respect to your elders, past and present, Matthew, to your family, to your mum, and thank you for your welcome. It's always good to have a welcome that ensures that this place is a place where we do respect each and every one of us. And it's always good to have those spirits looking after us. But I've just got to say from the very start, they didn't look after me very well when I did some of the interviews for this lecture. So I'm going to apologise for the quality of some of them, particularly the one that's done on the Antarctic winds blowing on Bruny Island in Tasmania with Rodney Dillon. So please bear with that. Look, I also want to say thanks to my family for coming today. They often don't get to see some of my talks, but I've got to say I'm just absolutely overwhelmed. And you know, while it's a little bit tongue-in-cheek, Judge Yates, your introduction to everyone, if I wasn't nervous then, I certainly am a little bit now. Look, it is a great honour to present the 2012 Sir Ronald Wilson Lecture. I did meet Sir Ron on a number of occasions, and many of you will be aware of his role in the establishment of the Aboriginal Legal Service here in Perth in the early 1970s. Today I want to explain the impact that British and Australian law has had on the First Peoples of Australia, and specifically on Aboriginal people here in WA. I hope that a positive from my talk is an understanding of how we as a people feel about what has happened. I want to go beyond legal discourse. I want to discuss not just our very humility, but our very humanity as well. To me, this does, Judge Yates, capture the essence of Sir Ron. A man who was small in stature, he was only a little bloke, but of course we all know he was just gigantic as a social change agent through his own sense of humanity and his commitment to making our world a better place to live. With this in mind, I want to give you a personal account of the impact of Western law on our peoples, both from my own perspective and that of some other Aboriginal people, including Dr. Noel Nannup. Dr. Nannup is a highly respected Noongar elder. He's a consultant, storyteller, cultural mentor, and he's Edith Cowan's cultural ambassador, and he shares his views on the impact of Western law upon Aboriginal people.
Okay, I think across the board that's the stolen generation, and personally it's my dad, because my mum was taken away as well, but Dad was only 5 years old, and anything to do with his Aboriginality, he told me, was flogged out of him by the time he was 7. So, you know, that's a memory I carried. But then of course you've also got a different law, and in many instances when you think of Wongai people and Yamaji people, even today they're subject to two laws, you know. They might commit an offence out there that's really serious. They come down here, they go through the legal system we're all subjected to as Australians, and then they go home and they have to go through Aboriginal law.
An historical account from Dr. Nana. We'll hear a little bit more from Noel later on. The impact of Western law is also evident in contemporary life today, as Professor Colleen Hayward explains. A senior Noongar woman, Professor Hayward is the head of Kurungul Katajan at Edith Cowan University, and this year was made a member of the Order of Australia for her service to tertiary education and the advancement on the rights of Indigenous peoples, particularly in law and justice, children's health and social welfare.
For me, the major impact of Western law is summarised in a story of us going out for my brother's birthday earlier this year. We were in Northbridge and all of the family was together, and as we headed back to the car park where we were all parked, there were about half a dozen police officers rousting quite a young Aboriginal man. He was clearly embarrassed to be in the situation and was just quiet. He was just quiet, he was surrounded, he didn't do anything, and clearly after a while when they told him to move along, that's what he did. But I did what I always do, which was stand close enough to not be in the way, but also close enough to observe clearly. My two brothers stood with me, and for the whole time they looked at the ground. And they looked at the ground because neither of them wanted to get into trouble by making eye contact with any of the police, and they each stated, quite independent of each other, that they didn't want to be tasered. Now, that response in them, automatic and without prompting, goes to the place of belonging and pride and self-respect. And until we can address those things so that we are all comfortable in our own country, we still have a long way to go as a nation.
We'll hear from others throughout this lecture about the impact of Western law upon Aboriginal people, as well as posing the question, does Aboriginal customary law have a place in Australia today? The origins of the concept of terra nullius, which have affected Indigenous peoples since colonisation, do not lie in British law. They lie in the Catholic Church and in a series of papal bulls or charters issued in the 15th century. Native American Steve Newcomb has described these papal bulls as effectively a declaration of war by the principalities and monarchies of Christendom against all non-Christian people. These papal bulls and subsequent edicts and legal principles based upon them have been used for centuries to dispossess Indigenous peoples of their lands and to facilitate the transfer of land and its resources to colonising powers. This later became known as the doctrine of discovery, hence my title. This doctrine asserted that Christian nations had a divine right to claim title over so-called discovered land and to exercise authority over the inhabitants. Unsurprisingly, Indigenous peoples around the world have been fighting against this for over 500 years. In Australia, the idea of terra nullius, which came out of the doctrine of discovery, is more familiar to us. In 1770, the British government's official instructions to Captain Cook stated that he was, with the consent of the natives, and we've got to emphasise that was with the consent of the natives, to take possession of convenient situations in the country in the name of the King of Great Britain, or if he found the country uninhabited, to take possession for His Majesty. Let's pause as we hear some more views about how Western law has impacted upon Aboriginal people. Les Melzer is a Gubby Butchulla man. His people are from the southeast Queensland, and he is currently the co-chair of the National Congress of Australia's First Peoples.
Well, it's quite clear, looking back on the history not only of Australia but around the world, that for Indigenous peoples the impact of colonisation has been devastating. It's led to, of course, the taking of territories and resources, but also massive destructions of populations, huge impact on cultures and so on. Fortunately, and in Australia we have been able to do this also, Indigenous peoples have found a way to survive through genocide policies, through massive actions and so on. And not only that, but Indigenous peoples continue to survive in their territories, have been able to maintain the biodiversity that exists in their territories, and to keep the environmental health of the world going and so on. So this has been a very big contribution Indigenous peoples have made to the survival of the world over the past centuries, and in Australia in particularly it's very important because this country is very much a spiritual country. It's different from other parts of the world in many, many ways, but it's very much a spiritual land, and this country can only survive if that spiritual contact is maintained, that Aboriginal people are so important for the continuing health of the land, the environment and the spirits that exist in this area.
Sharing the co-chair role on the National Congress of Australia's First People is Jodie Bruin. Jodie is a Yinjibarndi woman from the Pilbara here in Western Australia. For Jodie, Western law has impacted in a way that many of our people can relate to.
I think because my mum is a member of the Stolen Generations, I would have to say the laws that allowed children to be taken from their families has probably had the highest impact on myself and my family. And you can't, we can't go backwards. But, the reparations and recompense for that sort of thing, I think it's really important. And it's something that's going to linger into the future because it has had such a widespread impact, and it goes down through generations.
Aboriginal people and Torres Strait Islanders never gave our consent for our lands to be taken in the name of the British King, and our strong resistance to dispossession and defence of our sovereignty continue through to this very day. But this did not stop terra nullius becoming the basis of British colonial and later Australian law. Aboriginal sovereignty was deliberately denied, and Aboriginal lands declared uninhabited in a series of colonial statutes. This was an international context of the application of Western legal systems to justify seizure and disposition of Indigenous lands. In the United States, in 1823, the Supreme Court in the celebrated case Johnson versus McIntosh asserted the doctrine of discovery over Indian lands. The case established that the United States, when it won independence in 1776, became a successor nation to the right of discovery of non-Christian lands. The Supreme Court claimed that Indians or Indigenous Americans had lost their rights to complete sovereignty as independent nations and only retained a right of occupancy in their land. In other words, Indian nations were subject to the ultimate authority of the Christian nation, in this case the United States. First Peoples around the world have for centuries protested against these unjust laws which robbed us of our lands and provided a legal framework for destructive and genocidal attacks by the colonial powers on First Peoples and our cultures. At the United Nations Permanent Forum on Indigenous Issues in May this year, Indigenous and Native peoples condemned the continued use of the internationally recognised principle of terra nullius and called for the United Nations to repudiate the doctrine of discovery. In Australia, the doctrine of discovery and a body of colonial, then state and federal laws targeting Aboriginal people have been devastating for us. They have stripped us of our human rights and our inherent rights as the rightful owners of this country and its resources. They have robbed us of our inheritance and changed forever our destiny and that rightful future. They have discriminated against us and committed acts of genocide on our peoples. To fully understand the human impact of this legal attack goes far beyond any simple understanding of the laws themselves. What I seek to do today is to give you some sense of the impact of past and present laws on Aboriginal people, but at the same time emphasise how Aboriginal law has endured. I will also talk about how the recognition within our Australian legal system of Aboriginal law and Aboriginal sovereignty is a major step towards reconciliation. Before I share my thoughts with you, I'd like you to hear from a Palawa elder. I was in Tasmania during NAIDOC week in my capacity as the director of one of the directors of Congress. NAIDOC always brings our people together to share in the celebration of our achievements and reflect upon where we stand in the history of this nation. I spoke with Rodney Dillon, an Indigenous campaigner for Amnesty International, about the impact of Western law in Tasmania.
I think the impact of the law itself has been that it's interfered with our culture as an Aboriginal person to keep your culture going. The destruction of the Living Marine Resources Act, also the other acts that national parks have got. They have completely tried to stop us from practicing our culture. I think in the ways of they've denied us for 35 years to be able to get mutton birds. They've denied us the right to be able to take the mutton fish, and they've put laws in. Living Marine Resources Act has been that strong for Aboriginal people not to be able to practice their culture because they've been too frightened because of such heavy fines. So that's been very destructive, and there's been very little negotiation sense for us to keep practicing our culture.
To ensure that reconciliation survives as a core value of our national identity, we need to enshrine a respect for each other's humanity, as Sir Ron Wilson and so many other Australian human rights activists have done before me. I'll start by describing my experience of this land as a Noongar man, here in the country of my ancestors, a journey which I have been very fortunate to share with my family. I want to invoke for you a time when Noongar country, culture and community were all protected by Noongar law and spirituality. Here we sit today. If we remove the floor, the walls and the ceiling, it is possible to imagine a beautiful, powerful and awe-inspiring natural environment, an environment created by Wargle. Wargle, the great Noongar creation spirit, took the form of the serpent as it created this landscape. This journey of creation started inland and moved slowly to the coast. Our story starts at Garrakatta. This place is sacred to Wargle, as it lies where the great serpent emerged and rested. It is now known as Mount Eliza, and it is where our WA Parliament House stands. I want to take you on Wargle's journey down the Derbil Yurigan, which is of course the Swan River, from the Melville waters to the ocean, and then returning to Garrakatta and Parliament House. Refreshed and rested after emerging from Garrakatta, Wargle stretched, did a full circle to the right, allowing one last look back at this special resting spot before continuing its journey. The last look created what we now call Matilda Bay. Wargle, for reasons known only to the Great Serpent, moved in a circular motion, creating the vast stretch of water called Doontanburra, the Big Pelican River, now known as Melville Waters. It is still possible today to see where Wargle plunged deep into the ground and created Burrundungup, the place of deep water. You may know it better as Alfred Cove. Wargle then goes due north again, swimming in a circle, pushing rocks and soil from to form riverbanks and mud flats. This activity creates Minderup and Karrakatta, known today as Freshwater and Mosman Bays. Wargle again decides to rest and dives deep into the earth again, creating the deep water holes along Genelup, known today as Blackwall Reach. Wargle then relieves itself, We know this because its guna, or excrement, can be seen today. It is Wargul's guna that are the limestone cliffs of this area. Wargul, now feeling relieved and cooled off from the deep water, makes one mighty turn before heading towards the coast, creating Rocky Bay, and then turning around to finally go deep into the river bank. The caves found here at Wargul's final resting place before making its way to the ocean are named Gurrunga. The guna or limestone once again indicates a special place of rest. Wargul is not the only creation spirit for this stretch of the river. The mouth of the river is also was guarded during the creation time by 7 dogs, Dwerdas, at Dwerda Wheeler Dinup. This hill is now known as Containment Hill. We've included that one because we thought it's a little bit ironical that the dingo flower sign is where the dog dreaming starts. During the creation time, these dogs had to fight off a crocodile from the north, stopping it from entering the Derbil Yurigan. One of the dogs bit off the tail of the crocodile. The crocodile sank to the mouth of the river, forming the rocky bar that was at the river's mouth. Then the great spirit, Serpent, populated this place with all the plants and animals, and finally his children, the Noongar people. Wargul was kind to this place. The animals had soft padded feet and had very little impact on the beautiful flowers and plants that grew here. The Noongar people took up all the most beautiful spots along the river, places where the sweetest fruit grew and the water was fresh and cold. Life was good. I try and make the journey from Perth to Fremantle along the river as much as I can. I will always go down on one side of the river bank and come back on the other side. You see, I too have my favourite places as I follow this ancient dreaming track. Another place not far from here is the old Swan Brewery site. It is a good place to fish. Sometimes you can get the large jewfish coming past as they go through the narrow part of the river. This ancient resting place of the Wargul is important. It was here that you could get fresh water and hunt the yonga, the kangaroo. The Noongar name is Guninana. It was the place where Noongars would attend to the Wargul's eggs and carry out ceremonies for this purpose. This was the land of the Murro Noongars and their great leader Yalagonga. It was a meeting place for inland Noongars to come for male initiation and economic exchange. It was a recognised area for the trade of red ochre. This was a place of plenty. The fishing was as good then as it is today. Crabs and prawns were on the diet, and frogs long before they became famous through French cuisine. Another favourite stop is the Claremont Jetty. This whole area had many freshwater springs and was considered a healing place, hence the name Freshwater Bay. Like then, it is still considered today as a special place to live. It seems it was always thought of as upmarket. This was a favourite camping area for the Wajak Noongars. I stop here during certain times of the year to throw out my crab nets off the jetty. It is a place I know I can get the big blue manners. The sandbar in Freshwater Bay is a favourite place for people to anchor their boats and drop their nets. The sandbar's Noongar name is Karakata, and it would not surprise you to know it means not the place of death, the place of crabs. My last special place on this side of the river is at the shallow banks on the north side of the Fremantle traffic bridge. This was a much favoured spot for the Murro Noongars, who would use this shallow place as a crossing en route to Bibra Lake, Rockingham and down to Mandurah. To the Murro, this place was also a place of plenty. This is very close to where the original mouth of the river was and where the place where the dog spirits fought with the crocodile. The shallow bank provides good fishing, and this is especially good for flathead and flounder. It was here that an Eggington legend was born. I was standing in the shallow banks of the river, almost under the Fremantle traffic bridge. I did become aware that several dolphins were moving backwards and forwards between where I was and the traffic bridge. This concerned me, as I knew that they would be scaring the fish away. But to my astonishment, a very large shadow began moving towards me. I got a little bit frightened, to tell you the truth. The water erupted into a boiling mass with thousands of fish exploding all around me. The dolphins, in fact, were doing the very opposite of what I feared. They were herding this very large school of mullet past me and up onto the bank. A once-in-a-lifetime experience that will no doubt become a family favourite. A time when Grandpop swam with the dolphins and brought back fish for the whole family. Legend may even have it that in fact Pop can speak dolphin and called them to bring the fish in. It is important to note that activities such as this do have a long tradition in Noongar history. My first stop on my return journey is at the limestones of Blackwall Reach. As I have previously said, our Noongar name for this special place is Jenalup. Jena is the Noongar for foot, and the suffix up is place of. Jenalup therefore is translated as the place where feet make a track. The area was and remains a very special place, a place of fresh water and a connection to the spirituality of Wargle, a place for women and children. We enjoy this area as it remains somewhat wild and untamed. It is good for fishing, and I am of the opinion that many of our river fish shelter here in the deep water. Our last place is Point Walter. We stop here because the jetty is a good place to fish, and sometimes we have a barbecue before heading home. This was a good place for the women and children to cross the river, going along the long white sandbar. The sandbar's white sand is called Doondalup, meaning place of white sand. The white sandbar was created in the dreaming by the white hair of a woman's spirit ancestor falling down and landing in that part of the river. On many occasions, this regular pilgrimage fills me with mixed emotions. I have to be honest and say that I do get angry when I look for all of those special places in the haunts of our peoples. Why are we no longer there? What is it that continues to keep our places from us, treating us as strangers, as trespassers in our own country? We are the oldest living surviving culture in the world and have a rich tradition of culture and law. But with the impact of Western law, does Aboriginal customary law still have a rightful place in Australia?
It's a great question, but I'm not sure. You see, you've got to weigh the whole lot up. There's a lot to weigh up. And at the same time, the old law, I believe, is slowly adjusting and adapting to the new way. But you still get some of the floggings, you know, when cars roll over, people are killed. I've witnessed that myself, you know, when I lived in the Kimberley. You wouldn't wish it on anybody. But at the same time, you weigh that against Westminster law, if you like, or whatever you have, and it's just as horrendous. Aboriginal people are not meant to be in prisons, full stop.
Look, I think customary law has got a place. I think where it really needs to be reinvigorated and it needs to be strong, but it's really connected to really strong culture and language, and I think we can't separate those things out. It needs to be respected and have its place within the broader legal system, I think, and to be taken account of in sentencing and things like that. But more so, I think it's about how communities wrest back control of those sorts of things themselves.
Aboriginal law still survives, that there's been a tendency for people to think it's gone and it's going, that it's been a concern to see, for example, in the area of traditional health practices, that these seem to be disappearing from the Aboriginal health systems when they shouldn't be disappearing. There should be an effort to maintain that. So not only should the continuation of tradition and law be maintained, it actually should be strengthened. There should be a return of people back to their cultural ceremonial obligations to land and so on. And it's because of the importance of the law that sets our social responsibilities, our social behaviours and so on. And a big part of that is language. We have a great diversity of languages in Australia, between 250 and 600 languages, and those languages are all destined to die out if nothing is done to change that. So Congress has made a big issue of late of saying we must continue to strengthen our languages. Our resolve there is that by strengthening our languages, we continue the survival of the law. We get people back to doing cultural things such as walking on country and doing ceremony for country and so on. That this is the way we've got to start thinking now. It's not only about going to university or getting into a home that we own and so on. It's actually, those are just means for us to continue to survive in the way that we are meant to survive as Indigenous peoples. 40,000 years or more in this country, and 40,000 years or more into the future. We have to survive. That's our obligation.
Look, I look around and see the ground once protected by those soft pads of those animals long gone. In its place, the destruction caused by the hooves of those papal bulls sent to rob and plunder the lands of my ancestors. The theft of Aboriginal land has had the greatest impact on our peoples and remains at the heart of our struggles. That is why we use the phrase was, is and always will be Aboriginal land. That is why our continued calls for the recognition of sovereignty are still echoing around this country of ours as they have from 1770 onwards. Now I would like to take you on another kind of journey. Aboriginal Australians as British subjects were supposed to enjoy the same rights and protections as every other British subject. But it wasn't to be. When Australia became a nation with a federal constitution in 1901, the civil and political rights of Aboriginal people had already been undermined in several colonial statutes, even though in Western Australia and in other states, the right to equality before the law had been denied in the way that Aboriginal people were dealt with by the courts. The legacy of this endures today in extreme racial disparity in our justice system. The combination of the White Australia policy, one of the very first pieces of legislation passed in the new federal parliament in 1901, and the exclusion in the new Commonwealth constitutions of the power to make laws for Aboriginal Australians and other Indigenous peoples, meant that the oppressive and racially discriminatory regimes established in the states were left to flourish unimpeded. In Western Australia, we had the notorious Aborigines Act of 1905. Aboriginal people in Western Australia still talk about this as an act which took away so many rights that they had previously enjoyed, and condemned Aboriginal communities and families across the state to generations of poverty, segregation and the heartbreak of having their children taken away. The 1905 Act, which set the pattern of systemic abuse that continues today. Throughout the decades since, we have protested at being denied citizenship in the country of our forebearers. Rather than being frozen in time, these acts do not sit uncomfortably in the past. Their tentacles span generations and reach deep into the present. We are still fighting for basic human rights today because of these past acts of inhumanity. The 1905 Act gave the Governor power to declare certain areas prohibited to Aboriginal people not in lawful employment, and to establish reserves to which unemployed Aboriginal people could be forcibly removed on orders of the Minister. Aboriginal people could also be arrested without warrant for offences against the Act, and if convicted, could be jailed for 6 months. If Aboriginal people left their employment without permission, they could be charged with an offence against the Act. Marriages between Aboriginal women and non-Aboriginal men required approval by the Chief Protector. The Minister was granted the power to exempt certain people of Aboriginal descent from the Act, but the certificates of exemption could be cancelled at any time. The Chief Protector was made the legal guardian of all Aboriginal children under the age of 16 years, and amendments in 1911 extended this power to guardianship over illegitimate children against the rights of the mother. These were the sections used by the Department to forcibly remove children from their families. Made for the so-called protection of Aboriginal people, these laws fostered systemic human rights abuses across Australia. Many non-Aboriginal people are now surprised to learn that these unjust and racist laws were not finally repealed in Western Australia until 1972, just 40 years ago. As with the laws that tried to deny Aboriginal sovereignty over land, we protested against these laws that sought to deny our civil and human rights. Among the many letters written to the government, Noongar man John Kickett wrote to the Premier, Mr Griffiths, in 1918, protesting that while some of his people had enlisted in the Australian Imperial Force and were fighting in the trenches in France, his children had been refused permission by the Education Department to go to the local school in Quairading. As Kickett wrote, "My people are fighting for our king and country, sir. I think they should have the liberty of going to any state school." A lifelong activist for Aboriginal rights, Yamatji leader William Harris, headed a delegation of Aboriginal people from around the state in 1928 to see the Premier, Mr Collier, objecting to the absurd regulations of the Aborigines Act, words that Harris used. Aboriginal people gave evidence at the Moseley Royal Commission in 1934. A Noongar man named David Nannup complained that the Chief Protector, Orba Octavius Neville's decision to incarcerate some of his children and grandchildren at Moore River settlement was unfounded. Nannup hired a lawyer to argue that he and his family should not be subject to the Aborigines Act. Aboriginal witness John Egan also protested against coming under the control of the department and told the Commission that he wanted to live where I can get work as a free Australian. Arthur Thompson wanted exemption from the 1905 Act so that he could just get his reader out of Moore River Settlement. For those of you who don't know, Moore River Settlement, north of Perth, was established by the Aborigines Department in 1918 as a segregated government institution to which Aboriginal children and town camp residents were forcibly removed under powers conferred on the minister in the Aborigines Act of 1905. Evidence presented to the Moseley Royal Commission by Aboriginal former inmates, and that was the term used in the government records, inmates, and their relatives portrayed Moore River Settlement as a place of hunger, poverty and brutal punishment. Noongar witness Alfred Mippy declared that he would not stop there and that it was the last place any Aboriginal person would want to go. Even Commissioner Moseley, who was generally sympathetic to the Aborigines Department and its staff in his report, described the settlement as a woeful spectacle. Under the disguise of being an educational institution for young Aboriginal children, in reality it was nothing more than a cheap source of labour. Like the brave young girls in the true story Rabbit Proof Fence, our people were incarcerated in places like Moore River for no other reason than they were Aboriginal. As a further illustration of how difficult it was for us to exercise our basic civil rights during the 1934 Royal Commission, Chief Protector A.O. Neville, nicknamed Neville the Devil by some, was able to cross-examine the witnesses who were critical of his department and its treatment of Aboriginal people. The Aboriginal witnesses knew that Mr Neville had the power to take away their children and to remove them and their families to squalid settlements like Moore River. Yet they risked it to publicly protest against their treatment and to demand their rights as free Australians. During the era of the Civil Rights Campaign of the 1960s, significant changes occurred for Aboriginal peoples in Australia. In 1962, finally after half a century of federal democratic government, Aboriginal people and Torres Strait Islanders were accorded the same voting rights as other Australians in Commonwealth elections. In 1965, Charles Perkins led the freedom rides throughout country New South Wales to protest against racial segregation, and this campaign attracted widespread media attention. In 1966, Australia became a signatory to the International Convention on the Elimination of All Forms of Racial Discrimination. In 1967, Australians voted overwhelmingly in favour of changes to the Constitution, which gave the Commonwealth Government power to make laws for Aboriginal people and Torres Strait Islanders, a move for which our activists and their supporters have been campaigning for decades. This was the final challenge to the maintenance of racially discriminatory regimes in the states and territories, and by the early 1970s, most of these laws had been repealed. But living conditions for Aboriginal people and Torres Strait Islanders remained appallingly bad, and by all major indices of health, housing, employment, imprisonment rates, the gap between black and white Australians was huge. With the election of the Whitlam government in 1972, the fledgling Aboriginal legal aid organisations around Australia received a substantial boost in funding. They were confronted with a huge demand for their services when Aboriginal people for the first time had access to their own legal representation so that they could take their cases to court. As they pressed for land justice and to protest against what they knew was the fundamental wrong of dispossession, the first major land rights case was in 1971 with the case of the Mirrapum and Nabelco versus Nabelco, when Yurunga people from the Gove Peninsula in the Northern Territory government took Nabelco Mining Company and the Commonwealth government to court in an effort to stop mining on their country and to assert their traditional land ownership. Justice Blackburn of the Northern Territory Supreme Court determined that although the Yurunga law was clearly a system of governance, it was not a part of the law of any part of Australia. Although it's an important precursor to the Mabo decision, Mirrapum versus Nabelco was a disappointment for those fighting for the recognition of traditional land rights. Further recognition of Indigenous sovereignty was still far from the mainstream political agenda, although it always had been on the agenda for Aboriginal rights campaigners. In the late hours of Australia Day in 1972, 4 men involved in the Black Power movement, Michael Anderson, Bill Craigie, Bertie Williams and Tony Curry, set up an umbrella outside Parliament House in Canberra with a sign saying Aboriginal Embassy. The word embassy was deliberately used to signify the lack of land rights that Aboriginal people had in their own country. When the police were called the next morning, they soon discovered that there was no law against campaigning on Crown land, and the Aboriginal Tent Embassy was born. In 1975, Australia finally implemented the provisions of the International Convention on the Elimination of All Forms of Racial Discrimination in domestic legislation by passing the Racial Discrimination Act. On the 5th anniversary of the Tent Embassy in 1976, the Aboriginal Land Rights Northern Territory Act was passed by the Federal Parliament. This was the first law in Australia that enabled Aboriginal applicants to claim land if they could show evidence of their traditional association. For successful claimants, land was granted in fee simple. It's like a communal freehold. In the celebrated challenge led by Eddie Mabo on behalf of the Mirram people of Mer Island, the High Court of Australia finally shattered the legal fiction of terra nullius in 1992. The court found in Mabo versus Queensland No. 2 that Australia was in fact inhabited at the time of British occupation, and that Torres Strait Islander people had legal rights to their traditional land unless those rights were validly extinguished. The Mabo judgment recognised our rights to land. For those groups who could demonstrate that the laws and customs which supported land ownership predated the declaration of British sovereignty, their native title was recognised under Australian law. As Chief Justice Robert French recently wrote, the Mabo decision made recognition the informing metaphor for the common law of native title. But while the Mabo decision was celebrated by Aboriginal and Torres Strait Islander peoples and our supporters as a recognition that the land always was ours, it was not a recognition of our sovereignty. The Australian government finally responded to the decision with the Native Title Act in 1993 and the establishment of the National Native Title Tribunal to administer the native title claims process. The Indigenous Land Corporation was established by legislation so that Aboriginal and Torres Strait Islander peoples who did not have access who did not have a chance to secure land through the native title process were assisted to buy and manage land for their economic, environmental, social or cultural benefits. The Keating Labor government also committed to establishing a social justice package with a raft of measures to ameliorate Indigenous disadvantage, including addressing the legacies of dispossession and child removal policies. However, the Keating government lost power prior to implementing this package, and the succeeding Howard government ensured that it never happened. Laws are the privilege of the prevailing government. The Native Title Amendment Act 1998 then significantly increased the burden of proof for native title and sought to enshrine in legislation the bucket loads of extinguishment of native title promised by the Deputy Prime Minister, Tim Fischer. The amendments to the Native Title Act were criticised by the United Nations Committee on the Elimination of Racial Discrimination, who suggested that the new legislation failed to meet Australia's obligations under the UN Convention to which Australia is a signatory. Under the Howard government, we saw repeated attacks against the hard-won changes to Australian law. The Constitution, as it currently stands, is ineffective in protecting Indigenous people from the most fundamental of all freedoms, the freedom from discrimination. Discrimination based on race is prohibited under the Racial Discrimination Act. But because this is not constitutionally entrenched, it can be amended, suspended, and even repealed through the passage of further federal legislation. The Australian Parliament has suspended the Racial Discrimination Act on 3 occasions, each time adversely affecting the rights and fundamental freedoms of Indigenous peoples. In 2007, this approach enabled the Northern Territory Emergency Response, also known as the NT intervention. Under this legislative framework, the Australian Government prescribed 73 remote Northern Territory Aboriginal communities and sent in the Army. Medical teams were also sent to conduct compulsory sexual health checks on all Aboriginal children, a move which was strongly opposed by key Indigenous NGOs and mainstream medical professionals in Australia. It will be a time, I remember, two men from the Aboriginal Legal Service, one of them, an elder, came to me and said, "Come into this boardroom, I want to pray, Dennis." I said, "Right." He said, "I want to pray to God and ask him why he made me an Aboriginal man." That's the shame that he felt on all of the accusations that were being thrown around, which led to the NT intervention. The other was a court officer with us who said, "By hell is anyone going to touch my kids and give them sexual tests up in the Northern Territory?" I'll never forget those two men and what they said to me that day. It is any wonder that the contortions of Australian law continue to provoke Indigenous protests. From the first acts of dispossession, our sovereignty has never been ceded, and compensations for the loss of land and resources has not been negotiated on a systematic or comprehensive basis. The doctrine of discovery has perpetuated legal and moral justifications for many laws and policies that repudiated the rights and interests of our peoples. These laws and policies were justified and protected by the privilege of precedent, handed down through British law. As lawyers, as rational, intelligent and compassionate human beings, this is something that you in this room have the clear ability to change. You have the skills to do so. All you need, additionally, is the court, the heart. As I have sought to show this afternoon, being an advocate for reform is not only about the courtroom and challenging unjust laws from within the legal system. It is about educating yourselves and others, lobbying, acknowledging and condemning injustice. Because public perceptions affects government policy, and government policy affects the law, and the law affects my people and yours, We need a real commitment to improve the lives of our people and to ensure adequate protection of human rights for all Australians. To gain meaningful constitutional recognition of Indigenous peoples, it must be developed in an environment where Aboriginal people's sovereignty is not something we have to constantly fight for. It must be based on respect, respect between one people and another. Some may see this as a mere tokenship step, but no. The constitutional recognition of Indigenous peoples is not only beneficial to our Indigenous futures, it is an integral part of the healing process between Indigenous and non-Indigenous Australians. Much of the past, if bleak, is not just for Indigenous Australians. But let me finish on a positive note. I knew it wasn't going to be all warm and fuzzies, but let me finish on a positive note. And that note, I'm sure, would have been shared by Sir Ron. I don't know, you always call him Sir Ron. No, Sir Ronald Wilson, Sir Ron. My hope, and the hope I believe for all my people, is that one day our country will no longer need to rely on the long and arduous process of legal challenge. Instead, we will always work towards a better deal for all Australians, and we will achieve that better deal. The better deal can only be founded on a common recognition of our shared humanity. Aboriginal people, both now and in the past, have challenged unjust laws and practices. As we have done so, we have helped to rewrite our nation's history and, might I say, to improve the fabric of our society. That challenge of unjust laws must continue. But to create a truly just society, we must all, Indigenous and non-Indigenous, seek to challenge not only unjust laws but all injustices. That is the road towards a truly just society. Thank you all very much.